Tonight, we are not talking about a law that has already taken effect. We are not talking about a finalized rulebook. And we are not talking about a single announcement that instantly changes who can or cannot drive. What we are talking about is something more subtle, and in many ways, more powerful. We are talking about a shift in how senior driving is being discussed inside policy circles across the United States. A shift that has been building quietly, methodically, and largely out of public view. For decades, driving in America has symbolized more than transportation. It represents independence, autonomy, and dignity, especially for older adults. For millions of seniors, the ability to drive is not a convenience. It is a lifeline. It determines whether they can buy groceries, attend medical appointments, visit family, or simply remain connected to the world around them. That is why any discussion involving senior driving regulations immediately becomes emotionally charged. It sits at the intersection of safety, civil rights, healthcare, and personal freedom. And that is exactly why, in recent months, this topic has begun resurfacing with unusual intensity. A long-standing issue that never truly went away. Concerns about senior driving are not new. Transportation agencies, insurance analysts, and medical professionals have debated this issue for decades. The core question has always remained the same. How do we balance public safety without unfairly penalizing age? Historically, the United States has avoided sweeping, nationwide rules based purely on age. Instead, most responsibility has been left to the states. Each state sets its own renewal timelines, testing requirements, and evaluation standards. Some states require vision tests after a certain age. Others shorten renewal periods. A few mandate additional screenings only after accidents or medical referrals. This decentralized approach was intentional. Lawmakers understood that aging is not uniform. A 70-year-old marathon runner does not have the same capabilities as a 70-year-old with cognitive decline. Age alone, they argued, was an unreliable metric. And for many years, that logic held. So why is the conversation changing now? Over the past few years, several overlapping pressures have quietly pushed senior driving back into the national spotlight. First, America is aging rapidly. Every year, millions of drivers cross the age 65 threshold. This is not a temporary demographic spike. It is a structural shift. Policy planners are now dealing with the largest senior driving population in U.S. history. Second, traffic safety has become a renewed political priority. Nationwide accident rates rose following the pandemic years, and policymakers began re-examining every contributing factor, from infrastructure design to driver behavior across all age groups. Third, advances in medical assessment and cognitive testing have changed how impairment is measured. What was once subjective is now increasingly quantified. Reaction time, memory recall, and decision-making speed can now be evaluated with standardized tools, and those tools have found their way into policy discussions. Individually, none of these factors would trigger alarm. Together, they created momentum. The quiet phase before policy gets loud. People often assume that policy changes begin with announcements. In reality, they begin with silence. Inside Washington and state capitals, policy shifts usually follow a recognizable pattern. Early drafts circulate quietly. Stakeholders are consulted off record. Data is reviewed. Pilot studies are discussed. And sometimes, the most telling sign, previous proposals simply disappear. When conversations stop appearing publicly, it often means negotiations have moved behind closed doors. Transportation analysts and senior advocacy organizations have noted this pattern before. Long periods of quiet are frequently followed by sudden public frameworks, not incremental proposals. And when that happens, the reaction is rarely calm. This is why advocacy groups monitor these signals so closely. Not because they assume the worst, but because they understand how quickly a discussion can turn into a directive. Why seniors pay attention faster than anyone else. Unlike many policy issues, senior driving affects people immediately and personally. There is no abstraction. There is no delay. A change in licensing standards does not affect corporations or institutions first. It affects individuals, often those least able to adapt quickly. For seniors living in rural areas, driving may be the only practical form of transportation. For those with limited income, alternatives like ride services are not always viable. That is why even preliminary discussions create anxiety. And that anxiety is not about resistance to safety. Most seniors acknowledge that some individuals should not be driving. The concern has always been about how those decisions are made, and whether age becomes a shortcut where individual evaluation should exist. The core tension that defines this debate. At the heart of this issue lies a tension policymakers have never fully resolved. Safety demands standards. Justice demands fairness. When those two collide, the outcome depends entirely on implementation. If rules are narrowly targeted, medically justified, and individually assessed, they gain acceptance. If they rely too heavily on age as a proxy for ability, they trigger backlash. And that backlash, historically, has been swift. Senior advocacy organizations are among the most organized and experienced policy actors in America. They have navigated Social Security reform, healthcare legislation, and age discrimination battles for decades. They do not react emotionally, they react strategically. Which is why, whenever senior driving discussions resurface at a national level, they are never just transportation issues. They become civil rights conversations. Why this moment feels different? What has made recent discussions feel different is not a single proposal, but the scope of what is being considered. Observers note that conversations are no longer limited to vision checks or renewal frequency. They now include broader assessments of cognitive function, medical reporting responsibilities, and standardized evaluation frameworks. That shift signals something important. It suggests that policymakers are no longer asking whether senior driving should be reviewed, they are asking how aggressively it should be regulated. And once that question is on the table, the consequences extend far beyond traffic safety. Setting the stage for what comes next. Section 1 is not about predictions. It is about understanding why this issue is resurfacing now, and why it commands immediate attention. Because when policymakers revisit issues they once avoided, it is rarely accidental. In the next section, we will examine what kinds of proposals are being discussed, why they have ignited controversy, and why advocacy groups argue that implementation, not intent, is the real battleground. And that is where this story becomes far more complex, what is being discussed, and why it has triggered resistance. Now that we understand why senior driving has returned to the policy spotlight, the next question becomes far more sensitive. What exactly are policymakers talking about, and why has the reaction been so intense? It's important to be very clear from the start. There is no single national law currently in force that changes senior driving eligibility overnight. What exists instead is a policy framework discussion, a collection of ideas, evaluations, and proposed standards that are being reviewed at both federal and state levels. But history shows us something critical. Frameworks often become foundations. And that is why advocacy groups are responding early. The shift from vision to cognition. Traditionally, most senior driving evaluations focused on eyesight. Vision tests are simple, measurable, and widely accepted. They are also relatively non-controversial. What has changed in recent discussions is the focus on cognitive ability. Transportation safety analysts increasingly argue that modern traffic environments demand faster decision-making than in previous decades. Multi-lane intersections, complex signage, aggressive traffic patterns, and advanced vehicle technology all require rapid processing. From a policy perspective, this has led to one central idea gaining traction. If reaction time and decision-making affect safety, should they be evaluated more formally? That question alone has redefined the debate. Because once cognitive evaluation enters the picture, the issue stops being about driving skills and starts touching healthcare, privacy, and civil liberties. Renewal frequency, a quiet but powerful lever. Another area under discussion is license renewal intervals. Shorter renewal periods are often framed as administrative updates, but in practice, they dramatically increase scrutiny. More renewals mean more evaluations, more documentation, and more opportunities for licenses to be delayed, restricted, or denied. Supporters argue that frequent renewals allow earlier detection of impairment. Critics argue they create unnecessary financial and logistical burdens, especially for seniors living on fixed incomes or in rural areas. This is not a hypothetical concern. Every additional test requires travel, fees, and compliance with bureaucratic processes, all of which disproportionately affect older adults. Medical reporting, where policy gets uncomfortable. Perhaps the most controversial discussion point involves physician involvement. Some policymakers and safety advocates believe doctors should play a stronger role in identifying drivers who may pose risks. From a public safety standpoint, this sounds logical. But from a patient rights perspective, it raises serious concerns. Doctors are not traffic officers. They are not legal adjudicators. And they are bound by confidentiality and trust. Requiring medical professionals to report patients introduces fear into healthcare relationships. Seniors may avoid medical care altogether if they believe routine checkups could jeopardize their independence. That unintended consequence is one of the strongest arguments raised by advocacy groups. The age question no one can avoid. No matter how carefully proposals are worded, one issue remains unavoidable. Age thresholds. Once a policy sets a specific age marker, 65, 70, 75, it creates an arbitrary dividing line. A driver one day past the threshold faces rules that a younger driver with identical health conditions does not. From a legal standpoint, that raises constitutional questions. From a moral standpoint, it raises fairness concerns. From a political standpoint, it creates backlash. Advocacy organizations argue that ability should determine eligibility, not birth date. And courts have historically been cautious about policies that rely too heavily on age without individualized justification. Why advocacy groups are responding so early? To outside observers, the reaction from senior organizations may seem premature. After all, discussions are still ongoing. But for advocacy groups, early engagement is strategic. Once regulations are finalized, reversing them becomes far more difficult. Challenging frameworks before implementation allows groups to shape the narrative, influence lawmakers, and prevent harmful precedent. This is not panic. This is prevention. And it explains why responses have been coordinated, legal-minded, and unusually swift. Follow the incentives, not the headlines. Policy debates rarely exist in isolation. Insurance risk models, state budgets, and federal safety targets all influence how aggressively regulations are pursued. More testing means more administrative revenue. More restrictions reduce insurance exposure. More standardization simplifies enforcement. None of these incentives are inherently malicious, but they matter. Advocacy groups argue that when incentives align too neatly, safeguards are essential to protect individuals from being reduced to statistics. The real issue isn't safety, it's implementation. Even critics of proposed changes often acknowledge one uncomfortable truth. Some drivers, regardless of age, should not be on the road. The disagreement is not about safety goals. It is about how those goals are enforced. Policies that rely on individualized assessments, appeals processes, and medical nuance tend to gain acceptance. Policies that rely on broad age categories do not. And that distinction is what separates reform from resistance. Why this debate has escalated so quickly? This issue escalated because it touches something deeply personal. Driving represents independence. Losing it feels like losing agency. And once people fear that independence can be taken preemptively, opposition becomes inevitable. That is why discussions that might have unfolded quietly over years are now being scrutinized in real time, where this leaves us right now. At this stage, we are not witnessing enforcement. We are witnessing positioning. Policymakers are testing boundaries. Advocacy groups are drawing lines. Legal analysts are watching language closely. And the outcome will depend less on intent, and more on execution, what happens next, and why the next 60 days matter. At this point, the most important thing to understand is this. Nothing has been finalized yet, but momentum is building. And in public policy, momentum is often more important than announcements. What we are seeing now is a convergence of forces, federal agencies signaling concern, state governments watching closely, advocacy organizations mobilizing, and industry stakeholders positioning themselves for influence. The outcome will not be decided by a single press conference. It will be decided by what happens next. The legal path forward. From a legal perspective, any nationwide change to senior driving requirements would face immediate scrutiny. Age-based regulations are not automatically unconstitutional, but they are subject to heightened examination. Courts typically ask whether the policy is rational, narrowly tailored, and supported by reliable evidence. If a rule appears overly broad, or if it treats age as a proxy for impairment without individualized assessment, it becomes vulnerable to challenge. That is why legal analysts expect pre-implementation litigation, not after-the-fact appeals. Once enforcement begins, the burden shifts heavily toward affected drivers. Before enforcement, the burden stays with the government. That distinction alone explains why advocacy groups are acting early. The role of states, why uniformity is unlikely. Even if federal agencies push for standardization, driving laws remain largely state-controlled. That means outcomes are unlikely to be uniform. Some states may adopt stricter renewal requirements. Others may reject age-based measures entirely, many will land somewhere in the middle. This patchwork approach creates confusion, but it also creates protection. States with strong civil liberty traditions may resist federal pressure, especially where public transportation alternatives are limited. Rural states, in particular, face a unique dilemma. Restricting driving without offering alternatives risks isolating large segments of the population. Political pressure changes the equation. Driving policy does not exist in a vacuum. It intersects directly with elections. Seniors remain one of the most consistent voting demographics in the United States. Any policy perceived as threatening independence carries political cost. That reality forces lawmakers to tread carefully. Legislation that looks reasonable in committee rooms can become explosive once it reaches public awareness. And policymakers know that once voters feel targeted, compromise becomes harder, not easier. This is why many analysts believe future proposals will shift away from hard age thresholds and toward performance-based evaluations, if any changes occur at all. What families should be paying attention to? For families with older drivers, this moment is less about fear and more about preparation. Understanding renewal requirements in your state. Knowing your rights during evaluations. Being aware of appeal processes if testing is required. These steps matter regardless of whether federal discussions result in formal action. The most common mistake people make is assuming sudden change will come without warning. In reality, meaningful driving restrictions almost always follow extended notice periods, public comment, and phased implementation. Staying informed is the real safeguard. Why this issue isn't going away. Even if current discussions stall, the underlying issue remains. America's population is aging. Traffic environments are becoming more complex. Safety data continues to evolve. That means senior driving will return to the policy agenda again, if not this year, then in the next cycle. The question is not whether the conversation continues. The question is how it continues. Will it prioritize dignity and individual assessment? Or will it rely on broad categories that create unnecessary conflict? That answer depends on public engagement, legal oversight, and responsible reporting. The real takeaway. This is not a story about taking keys away. It is a story about how governments balance safety, independence, and fairness in a changing society. Oversimplifying it creates fear. Ignoring it creates vulnerability. Understanding it creates leverage. And leverage is what ultimately shapes policy. If there is one lesson from past regulatory battles, it is this. Policies that survive are the ones the public understands. That is why accurate information matters. That is why careful language matters. And that is why separating confirmed facts from developing discussions is essential. We'll continue tracking this issue as it develops, separating verified policy moves from speculation, and keeping the focus on what actually affects your rights and responsibilities. If you want clear, factual breakdowns of legal and policy developments like this, make sure you're following LawPulse News. We don't sensationalize. We don't speculate. We explain.